After studying this module, you shall be able to know about the significance of forensic science from legal viewpoint, the constitutional intricacies of forensic science in fair trial, and the importance and evidentiary value of forensic science in criminal investigation. Forensic science involves examination and analysis of objects and substances that have putative nexus with the crime and thereby provides vital links connecting the criminal to the crime. Based on Locard's principle of exchange, the examination of physical evidences left at the crime scene can assist in determining what might have happened at the scene of crime and who was and was not involved. It has immense contemporary significance in the justice administration system of a nation as it involves evaluation and interpretation of physical evidence collected from crime scene and therefore helps in location, identification, recognition and individualization of victims and crime suspects. The laboratory identification of a material such as controlled substance in a drug possession case, semen in a sexual assault or a volatile liquid in arson may assist in satisfying a legal requirement for proving that a crime occurred. Autopsies at homicide scenes will determine the cause and manner of death, and if the death was accidental, suicidal or homicidal. It has the capability of providing information about the crime otherwise unavailable to investigators and fact finders. However, despite the immense utility of forensic science to investigation, the contentious questions regarding its permissibility during investigation and relevancy and admissibility during trial requires special attention as to technological advancement can be allowed to override the rights of accused to fair trial. These questions can be answered by a careful analysis of various provisions of Constitution of India 1950, Criminal Procedure Code of 1973, Indian Evidence Act of 1872 and the Identification of Prisoners Act of 1920. Next is forensic science at investigation stage, permissibility and extent. The main purpose of investigation is to collect evidence by police. In modern times, the process by its very nature must enlist the services of several scientific disciplines. Information relevant to the process comes to the police in different ways, and in gathering scientific evidence, different types of coercion may have to be applied. But then we are a country governed by rule of law. Though there is no problem in collecting physical evidence from crime scene and sending it for laboratory analysis, but many a times to obtain evidence from the person of accused or for the purpose of matching the samples obtained from the crime scene, the suspect or accused need to submit him for various tests at the behest of investigative agencies. Herein Article 20 of subsection 3 and Article 21 of Constitution of India, which confers valuable rights against self-incrimination, right to life and personal liberty, including right to privacy, personal autonomy and right against torture respectively on the person of accused person comes into play. Therefore, before any forensic test can be ordered, it must firstly be authorized by an express provision so as to satisfy the constitutional prerequisite of due procedure established by law, and secondly, the said provision of law providing for such forensic tests must stand the scrutiny of the constitutional embargo. Various relevant provisions authorizing some specific or general form of forensic tests at the stage of investigation are Section 4, the Identification of Prisoners Act of 1920 empower police officers to take measurements of certain non-convicted persons, and Section 5 of the same law permits photographs of an accused person to be taken for the purpose of investigation. However, the Act has a limited scope, and as was deliberated in Ritesh Sinha versus State of Uttar Pradesh, it is highly doubtable whether measurements under the Act would include voice samples. Section 53 of CRPC empowers examination of accused by medical practitioner at the request of police officer, and Section 53A empowers examination of person accused of rape by medical practitioner. Under this section, examination includes the examination of blood, blood stains, semen, swabs in case of sexual offences, sputum and sweat, hair samples and fingernail clippings by the use of modern and scientific techniques including DNA profiling and such other tests which the registered medical practitioner thinks necessary in a particular case. In Kathi Kalu Oghad, the prosecution adduced in evidence a chit stated to be in the handwriting of the accused. In order to prove that the chit was in the handwriting of the accused, the police had taken specimen signatures of the accused while he was in police custody. Handwriting expert opined that the chit was in the handwriting of the accused. Question was raised as to the admissibility of the specimen writings in view of Article 20, subsection 3 of the Constitution of India. The High Court had acquitted the accused after excluding the specimen writings from consideration, conscious of the fact that the taking of impressions or parts of the body of an accused person very often becomes necessary to help the investigation of a crime. The court gave a narrow interpretation to the term "to be a witness," thus clearing the constitutional hurdle and paving the way for use of such test for purpose of investigation. But the problem comes with the forensic tests or techniques not expressly mentioned in the said section. For instance, the question relating to voice samples as permissible under Section 53 of CRPC is pending adjudication before a 3-judge bench of Honorable Supreme Court of India, as in Ritesh Sinha versus State of Uttar Pradesh. The 2-judge bench was equally divided on the opinion. Also, insofar as other prominent methods like narco-analysis, polygraph examination and brain electrical activation profile, the apex court in Selvi and others versus State of Karnataka reiterated the distinction between physical evidence and testimonial acts and held only the former category as permissible under law. The latter category is permissible only if they are voluntary and with express consent of the person concerned. Court acknowledged that the substances mentioned in explanation A to Section 53 are examples of physical evidence, and hence the words "and such other tests" mentioned therein should be construed to include the examination of physical evidence, but not that of testimonial acts. It has been held that the compulsory administration of the impugned techniques violates the right against self-incrimination. Section 311A of CRPC empowers the magistrate to order person to give specimen signatures or handwriting to aid in investigation. Next, we will be studying about the evidentiary value of forensic science. The purpose of investigation is to collect evidence. However, the entire evidence collected by investigative agencies cannot be received in evidence unless and until it is relevant. That is, the fact must be relevant under any of the sections from section 5 to 55 of the Indian Evidence Act. It is submitted that under section 7 and section 9 of the Indian Evidence Act, the forensic techniques and its results can be considered to be relevant. Section 7 makes facts which are the occasion, cause or effect of facts in issue as relevant. So, this section makes physical evidence collected from crime scene and also struggle or injury marks relevant as it is the effect of crime scene. Further, under section 9, facts which identity of anything or person whose identity is relevant or fix the time or place at which any fact in issue or relevant fact happened. Since the purpose of many forensic techniques is to establish the link between the victim, offender and place of crime, they become relevant under the before mentioned sections. Also, under section 45 of the Indian Evidence Act of 1872, when the court has to form an opinion upon a point of foreign law or of science or art, or as to identity of handwriting or finger impressions, then the opinion of experts become relevant. For instance, if the question is whether the death of a deceased was due to ante-mortem hanging or post-mortem drowning, then the opinion of expert becomes relevant. So, forensic experts can be called in the court to explain various nuances of scientific investigations and their conclusions. In fact, the term science appearing in section 45 has been given a wide interpretation as is sufficient to include the opinion of a person especially skilled in the use of typewriters and having the scientific knowledge of typewriters. In such cases, the expert in question needs to be made a witness in the trial proceedings because according to section 60 of Indian Evidence Act of 1872, if the evidence refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds the opinion on those grounds. Such an expert witness can be cross-examined by the other party also. However, the duty of the expert is merely to assist the court in finding the truth, and he is no substitute for the judge. An expert deposes and not decides. His duty is to furnish the judge with the necessary scientific criteria for testing the accuracy of his conclusion, so as to enable the judge to form his own independent judgment by the application of these criteria to the facts proved in evidence. A court is not bound by the evidence of the experts, which is to a large extent advisory in nature. Generally, the courts have followed a cautious approach and have been reluctant to base conviction merely on basis of expert testimony. The view occasionally expressed that it would be hazardous to base a conviction solely on the opinion of an expert handwriting or any other kind of expert without substantial corroboration is not, because experts in general are unreliable witnesses, but because all human judgment is fallible. The more developed and the more perfect the science, the less the chance of an incorrect opinion. An expert opinion has to be tested by the acceptability of the reasons given by him. Reasons for the opinion must be carefully probed and examined. All other relevant evidence must be considered. In appropriate cases, corroboration may be sought also. In cases where the reasons for the opinion are convincing and there is no reliable evidence throwing a doubt, the uncorroborated testimony of a handwriting expert may be accepted. If the report of an expert inadequate or cryptic and the information of similarities or dissimilarities is not available in his report and his evidence in the case, then his opinion is of no use. It is required of an expert, whether a government expert or a private one, if he expects his opinion to be accepted, to put before the court the material which induces him to come to his conclusion, so that the court, though not an expert, may form its own judgment on that material. Indeed, the value of the expert evidence consists mainly on the ability of the witness, by reason of his special training and experience, to point out the court such important facts as it otherwise might fail to observe, and in so doing the court is unable to exercise its own view or judgment respecting the cogency of reasons and the consequent value of the conclusions found thereon. The opinion is required to be presented in a convenient manner, and the reasons for a conclusion based on certain visible evidence properly placed before the court. Expert evidence can also be used as corroborative evidence so as to support or rebut the prosecution's story. An expert report, duly proved, has its evidentiary value, but such appreciation has to be within the limitations prescribed and with careful examination by the court. A complete contradiction or inconsistency between the medical evidence and the ocular evidence on the one hand and the statement of the prosecution witnesses among them on the other may result in seriously denting the case of the prosecution in its entirety, but not otherwise. Under section 293 of CRPC, the report of certain specified government scientific experts upon any matter or thing duly submitted to him for examination or analysis can be used in evidence without examining the author thereof, but a court is not bound to accept and act on a report as conclusive evidence of its contents. Evidence, though relevant, may still be inadmissible in the court of law. In case of forensic science, the inadmissibility of evidence is inextricably intertwined with the method involved. With respect to the evidence of sniffer dogs, the courts have held it to be inadmissible in Dinesh Borthakur versus State of Assam of 2008, 5 SCC 697. Supreme Court held the law in this behalf thereof is settled, that while the services of a sniffer dog may be taken for the purpose of investigation, its faculties cannot be taken as evidence for the purpose of establishing the guilt of an accused. In Selvi versus State of Karnataka, the apex court held that in case of narco-analysis, polygraph examination and the brain electrical activation profile, even when the subject has given consent to undergo any of these tests, the test results by themselves cannot be admitted as evidence, because the subject does not exercise conscious control over the responses during the administration of the test. However, any information or material that is subsequently discovered with the help of a voluntary administered test, results can be admitted in accordance with Section 27 of the Evidence Act of 1872. In cases where the paternity of child is disputed, through DNA techniques can be proven to be very useful, but they are generally not receivable in evidence because of the conclusive bar contained in Section 112 of Indian Evidence Act. Further, DNA test cannot be ordered without the consent of the subject in question. However, of late, the courts have tried to maintain a balance between the protection of a child from being bastardized and truth as evidenced through scientific techniques. So, proof based on a DNA test would be sufficient to dislodge a presumption under Section 112 of the Indian Evidence Act of 1872. Truth must triumph is the hallmark of justice, and the truth can be established through various forensic tests and therefore contribute immensely to justice administration system. Notwithstanding the legislative disinterest and lacunas to keep law abreast with modern science and technology, the courts have allowed such techniques to become an integral part of the investigation and also received the reports thereof in evidence while not compromising the rights of an accused to fair trial. Despite the near accuracy of scientific reports, the courts, though, have allowed the scientific reports but have been reluctant to accept them as sole basis for conviction and therefore seek corroboration. There is an urgent need to revisit the principles contained in Indian Evidence Act of 1872 to give more weight to scientific results. The acceptance of scientific results as conclusive will not only ensure a speedy trial, but also ensure that the accused do not take undue benefit of lack of credible evidence as a ground of acquittal.